Hi, can you guys see me? Can you hear me? Hello. Happy hump day. Hello, hello. I'm shook. I'm shook. I haven't even read these documents. We're reading them together. They're all fairly short, but we're going in, baby. Let's see. Hello, hello. Happy hump day. Thank you for coming back and supporting the channel and just being awesome. Welcome, welcome. If you are new, returning, hello, hello. Hi, lots of new subs too. Welcome to Mellyverse. I am Melly. We are going to be covering Madeline Soto case tonight. There's been a plethora of documents released. They're all a few pages, like 2 pages. Honestly, I don't even know what's in them. I don't know how important it is. I don't know if it's irrelevant. I don't know if we even, I don't know what's in them. So we're going to get through this together. We're going to read them. I'm not going to read all of them. It's too much. Trust, it's a plethora. I'm going to have to split it. I don't want it to be too long of a live because we are covering Karen Reed and Diddy as well. So I'm going to split this in between probably 2 or 3 lives just because there has been, well, it depends how much we can get through in a night, but there's been like 40 new documents released. So it's a lot. It's going to be one. Yeah, it's already a crazy case. If you're not familiar with the Madeline Soto case, she was unalived by her disgusting mother's, if you can call her that, broke live-in boyfriend. I don't know what he was. Stephan Sterns. He is in jail for 𝐭𝐫𝐬𝐞 and raping her since she was like 6 to like 13, pretty much, I think, something around there. And then for unaliving her. So it's a terrible case. I do have a whole playlist on that case. And I don't know, he is looking at the death penalty regarding this. He's the one that has like 1 million CSAM files. That guy, disgusting. He's disgusting. It's just one of those cases. It's a rough one for me. It sucks. My heart breaks for Madeline Soto. She was failed by everyone. You can watch the playlist to get caught up on how I feel about her. I do not like Jen Soto. I think Maddie needs justice, and that involves her mom being held accountable for child neglect. What do they call it when you're like a participant? I forget the legal term. Anyways, I think she needs to be held accountable. And I think she needs to be locked up as well. And she's been hiding out, and Stephan Sterns is serving time looking at the death penalty. I know there's a bunch of documents, so let's get started. Like I said, they're just a few pages. Hello, Osane. Hello, Four Wheeling. Hello, hello. I thought I saw Dodge in here pop in earlier. Thank you for being here. I appreciate you guys. Okay, so this first document, this was filed 6/10. So yesterday. I'm like, wait. Stephan Michael Sterns. I'm going to write in my notebook too. I'm one of those girls. I'm old school. Do people still write in notebooks or do they just have like tablets? I don't know. Can't stand Jen Soto. Don't get me started on Jen Soto. Don't get me started. She's up there with like Bev. Well, actually not as bad as Bev. But she's up there on, top females that probably shouldn't exist. Jen was no mother. Exactly. Oh, another notebook. Yeah, so tell me your secrets, all of them right now, so I can write them down. Jen was no mother. Nope. I think everyone in Madeline's life failed her. I do. I think everyone failed her. And then he just threw her out in the trees in the wilderness like she was trash. Did you say Beth? Yeah, okay, let's get started. So this first document is motion for special jury instruction on quote-unquote mercy. Like I said, filed yesterday. Come now the state of Florida by and through the assigned state attorney. And the state alleges as follows. She knew everything what was going on. That's what I think. That's Millie's opinion. A similar request was made and denied in Woodbury versus State. The Florida Supreme Court cited to Florida criminal standard jury instruction quote unquote, regardless of the result of each juror's individual weighing process, even if you find that the sufficient aggravators outweighs the mitigators, the law neither compels nor requires you to determine that the defendant should be sentenced to death. 2. Woodbury proposed a special instruction derived from the federal standard instructions, which added, "You may always consider mercy in making this determination." He proposed an alternate instruction that he claimed came from the Ether, which added, "Mercy itself is sufficient to justify a sentence other than death." 3. The Florida Supreme Court agreed with the trial court decision to deny Woodbury's request because the standard instruction adequately informed the jurors of the applicable legal standard. The Florida Supreme Court explained its analysis. When a juror votes for a life sentence, despite finding that the aggravators outweighed the mitigators and were sufficient to impose death, this decision is often referred to as a mercy vote. In fact, we have referred to the relevant provision of standard as, quote unquote, the mercy instruction. When it comes to jury's instruction, repetition is not required as it serves only to give undue emphasis. In fact, the Florida Supreme has warned against the use of repetition by trial courts instructing juries holding that there is no reason for saying the same thing more than once except for the purpose of adding emphasis to the statement. The court went on to note it had criticized such undue emphasis in a number of cases. Because the standard jury instruction is a clear and accurate description of the law, there is no need for a special jury instruction. The defendant's request serves only to be repetitive and forces the federal government's interpretation upon the state of Florida when two different standards are used. The jury's sentencing decision is binding in the court. In Florida, the jury's decision is a recommendation to the sentencing court. Therefore, the defendant's motion should be denied. Assistant State Attorney, what's his name? William Robert J. So I'm a little confused. Motion for special jury instruction on mercy. What does that mean? Like, that he shouldn't get the death penalty? They should give him mercy? No. I don't think so. Let's see. I think he should get the DP. If you see how bad the charges are. Hey, Jojo, good to see you. Okay, let me go on to the next one. Oh, I'm going to have to close out of the window, sorry, to go into each one individually. I'm going to pull up the next one. This one is states respond to defendant's motion for real-time transcripts. And this one is also filed on the 10th. It says Florida Rules of General Practice and Judicial Administration. I'm going to skip that. Section of the administrative order provides in part, quote unquote, whenever possible, real-time computer-aided transcription, ... shall be used in all death penalty cases. Therefore, the court should inquire the availability of real-time transcriptions for this trial and provide it if it is available. Wait, I hereby certify they're talking about like trial transcripts? Heck yes. Wait, they're allowed in death penalty cases to be public? I thought they weren't in death penalty cases. ... Heck yeah, we'll take it. I have to look that up regarding the DP. Let's move on. The next one is motion for personal service on potential jurors who do not respond to their summons and for the court to determine all excusals. Hey Dodge, good to see you, Liv. This is also filed, they're all filed on the 10th. So yesterday. This says Florida statute outlines which citizens are disqualified from jury service and who may excuse someone from jury service. The trial judge may delegate the task of excusing jurors that are prohibited from serving or that they have the option of refusing to serve. A trial judge is not required to oversee every excusal from the jury service. This does not deny a defendant's right to be tried by a jury representing a cross-section of the community. The defendant fails to allege what particular cross-section of the community is more likely to appear for jury service. Florida statute outlines the process for summoning jurors. There's no requirement for in-person service, and the statute outlines a penalty of a $100 fine or punishment as contempt of court. Also, there's no practical way to do what the defendant requests. We will not know which jurors fail to appear until each day a panel is summoned. It is impractical to suggest that we wait for personal service than to be had on each juror, under no statutory authority to do so, and then proceed with the jury selection. Therefore, the defendant's motion is denied. Ooh, they're all being denied. Yeah, wait, that's journey. We're covering Madeline Soto case. There's like a bunch of new documents, small little documents that came out. We're just going through them. We don't know if anything good is in there. I think it's all good. That's just me though. Basically, so far, I think we've gotten it. We're going to get the trial transcripts and that he's a pig and he should get no excusals. Moving on. So this one is motion for individual voir dire as to death, qualification, publicity, and hardship. What? The state agrees that the potential jurors should discuss any pretrial publicity individually to not taint other members of the panel. The trial court in this case agreed to individual voir dire of prospective jurors having any previous knowledge of the case, including from pretrial publicity. 2, hardship and scheduling issues can safely be discussed in large groups. 3, death qualification questioning can be accomplished with smaller panel of jurors, groups of 5 or 10 at a time. The determination of whether to grant individual or sequestered voir dire rests in the trial court's sound discretion. Therefore, the defendant's motion should be granted in part regarding jurors who indicate that they have exposure to pretrial publicity and denied without prejudice until the need for individual voir dire is developed during jury selection for hardships or death qualification. I think sequester them. Sequester them, right? It's a high-profile case. I think they should be sequestered. Let's see the next. These are just short documents, but there's like 40 of them. This one is motion for discovery of prosecutorial investigation of the jurors. The argument is that criminal defendants do have a right to pretrial discovery under Florida rule. As soon as practicable after the filing of the charging document, the prosecutor shall disclose the defendant any material information within the state's possession or control that tends to negate the guilt of the defendant. However, nothing in Florida rule of criminal procedure entitles defendant to the discovery of the prior criminal history of or information about potential jurors beyond the confines of Brady, which the state has agreed to already disclose. There is no general constitutional right to discovery in a criminal case, and Brady did not create one. This is evidenced by the repeated refusal of Florida's appellate courts that have repeatedly refused to order the type of broad disclosures the defendant seeks here without first demonstrating his efforts to obtain the information they seek on his own. Both the First and Second District Courts of Appeal have considered and rejected the defendant's assertion that he is entitled to the prior criminal history of prospective jurors. In the First District Court of Appeal affirmed the trial court denial of the defendant's motion for discovery of criminal records of the prospective jurors and state witnesses. The Monhannon Court dealt with the request as to the jurors. Secondly, appellant has cited no authority to support his contention that the state should have supplied him the criminal records of the prospective jurors we know of none. The Second District Court of Appeal reached the same result in Robertson versus State, affirming the trial court's denial of the defendant's motion for copies of complete and detailed reports on any and all prospective jurors. Wait, so the defense wants the history of the criminal history of the jurors? Florida courts have therefore recognized defendant is not entitled to the prior criminal history of the potential jurors beyond the requirements of Brady. Assuming the defendant could point to some binding authority for the state to disclose this information, the defendant would still need to show due diligence and attempting to obtain it on its own before the court could require disclosure. The Florida Supreme Court has apparently quoted the following when discussing the prosecutor's discovery obligation outside of Brady material. I'm not going to read that part. Thus, before the court compels disclosure from the state, the court must first determine whether all or any part of the information sought by the defense is readily available to them through diligence, and whether the defendant has exerted and exhausted efforts to obtain information. The defendant should not be permitted to so employ the pretrial discovery procedures as to require the state attorney to disclose him information or documents which by the exercise of due diligence are readily available to him. Put simply, the state has no duty to do for the defense work which the defense can do for itself. The defendant cites no case law which supports the state is required to disclose prior criminal history, especially if defense counsel has demonstrated no efforts to obtain those records. With reasonable diligence, defense counsel will likely succeed in procuring the veneer member's arrest history and information from social media platforms. The Orange County Clerk of Court's website makes public records readily accessible, so any user of the website may search for the person's criminal history. A Google search of the person names allows a seeker to view whether that person has any social media account. A juror's social media website can be readily available to any user of the website, depending on whether the account holder's privacy settings are public or not. The state accesses what is publicly available on social media sites. The information the defense seeks to compel from the state is equally available to the defendant through his counsel without having to compel disclosure from the state. Wherefore, the state requests that the court deny the defendant's motion for discovery of prosecutorial investigation of jurors. So the defense wants to look into all the jurors' background, and they want to point everything out, oh, this person did this because their defendant, the person they're defendant is a pig, and he did a bunch of things that he wasn't supposed to do, So now they want to judge all the jurors and look into them and make sure that everyone's clean there. Okay, let's move on to the next document. Okay, so that was investigating the jurors. Motion for disclosure of penalty phase evidence is the next one. All of these are pretty short, so that's a good thing about them. Let me see. Give me a second while I fix this. Okay, motion for disclosure of penalty phase evidence. The state agrees to fulfill its obligations under Florida Rule of Criminal Procedure. In Medina versus State, the Florida Supreme Court noted that the defense has the initial burden of trying to discover such evidence and that the state is not required to prepare the defense's case. Motion for disclosure of penalty phase evidence. See also state versus holding the state has no duty to obtain information for the defense. Okay, yeah, the defense is able to obtain by other means of production of the state, noting that a defendant should not be permitted to employ the pretrial discovery procedures for disclosure of information or documents which by the exercise of due diligence are readily available to him by subpoena or deposition. The Florida court has maintained this position. In Florida, defendants have the right to pretrial discovery under our rules of criminal procedure, and thus there is an obligation upon the defendant to exercise due diligence pre-trial to obtain information. The defendant should be required to follow the law and exercise due diligence during the discovery process. I'm confused with the defense is asking for the court to get all of their background or what and participate in this, and the state's do it yourself, Hey, 𝐭𝐥𝐥𝐲. We're covering Madeline Soto. So the next document is materials of specific officers on the list of law enforcement officers whose credibility is questioned by the Ninth Circuit State of Attorney's Office. Okay, so you guys, little Four Wheelan was mentioning it in the chat just before I started reading this. The person that was, I guess, a police officer or whatever, that was involved in leaking Madeline Soto's photo. Do you remember when they leaked the crime scene photo? That guy apparently just got arrested for the gambling ring. And so Fort Whelan brought it up, and I'm like, he was saying this in the chat, and I kind of agreed with him, like, does this affect the Madeline Soto case? The credibility of that police officer. I forget what his name is. I should look that up after this. But yeah, remember the police department accidentally, someone leaked the picture accidentally. Yeah, right. Okay, let's see. Come now, the state of Florida, by, through, and assigned under state attorney, states and alleges as follows. The state attorney office discloses to defense counsel any officer on the Brady list. Number 2, as the defendant states in his motion, Florida Rule of Criminal Procedure requires the state to disclose the existence of exculpatory evidence. 3, however, telling the defendant this information exists is different than retrieving it for him. Before the state can be ordered to gather this evidence for the defendant and provide it to him, the defendant needs to exercise due diligence to gather his evidence first. If he is unsuccessful, only then the court can order the state to gather this disclosed information to the defendant. In Medina versus State, the Florida Supreme Court noted that the defense has the initial burden of trying to discover such evidence and that the state is not required to prepare the defense's case, or that the defense is able to obtain by means other than the production by the state, noting that a defendant should not be permitted to employ the pretrial discovery procedures for disclosure of information or documents which, by the exercise of due diligence, are readily available to him. The Florida Supreme Court has maintained his position. The defendant's motion should be denied without prejudice. If he cannot obtain the disclosed information himself, he should then request the state to obtain it. If a dispute arises, then he can petition the court for relief. They're like, no. The next document is state's response to defendant's motion for a court reporter to note the race of all jurors examined during jury selection. Say what? The race? I can't deal. What does that even mean? The process for analyzing whether a party is properly using a preemptory challenge is outlined in Melbourne versus Florida. A party objecting to the other side use of preemptory challenge on racial grounds must A, make a timely objection on that basis, B, show that the venire person is a member of a distinct racial group, and C, request the court to ask the striking party for its reason for the strike. At this point, the burden of production shifts to the proponent of the strike to come forward with race-neutral explanation. If the explanation is facially race-neutral and the court believes that, given all the circumstances surrounding the strike, the explanation is not a pretext, the strike will be sustained. This third step requires a record to be made, including such factors as the racial makeup of the venire, prior strikes exercised against the same racial group, a strike based on a reasonable, equally applicable to unchallenged venire person, or singling out for the person for special treatment. Appellate courts have not hesitated to reverse a trial's court finding on the ultimate issue of pretext where the record does not support that finding. 3, the defendant states that the preferred approach to making this record is recording the race of all jurors, potential jurors, examined by having each juror state his or her race during voir dire. Wait, that's a thing? I didn't know that. The defendant cites no authority as to who thinks this is the preferred approach, quote unquote. The state has found no evidence that this is what is occurring in the courtrooms or that this is preferred. The state suggests that the court wait until the needs arise to do a Melbourne inquiry before asking all members of the venire to identify themselves by race on record. Hopefully no such objection will be made. However, if one is made, perhaps it can be resolved by the parties and the court agreeing that the potential juror belongs to a distinct racial group and the genuineness of the striking party's explanation can be evaluated with the record of the other members' answers provided. If there's some sort of the dispute over whether potential jurors appear to be a member of a distinct racial group, then the juror can be asked what he or she racially identifies as. If all else fails, perhaps it will become necessary to ask particular members or even every member of the venire what he or she racially identifies as, but the state would suggest we do not need to do that until the need arises. I'm confused. They look into when you're being put on a juror, Is that racist? I think that's racist. Like they just picked it. I didn't know that. They question your race. Motivation. The next document is motivation for compensation of juror at current wages and for reimbursement to primary caregivers for daycare costs. Oh, so this is oh my gosh, all this jury stuff is making me feel like, oh wow, the trial is near. When is the trial? I need to look that up. The exact dates. Is there exact date? I should know this. I'm trying to see if I can find it real quick before I read the next document. And no, I'll have to look into it. I thought it was this year. The jury trial is set for September 22nd, 2025. September 22nd. July. I think, yeah. WFTD says a jury, oh, that could have changed. That was like an older document. I'll get the exact dates for y'all because I need to know. Current wages. Okay, so what is this? A jury's compensation is a matter of legislative authority and not judicial prerogative. The defendant has failed to demonstrate that the Florida statute violates the fair cross-section of the community guarantees of the Sixth Amendment. In order to establish a prima facie violation of the fair cross-section requirement, the defendant must show that the group alleged to be excluded is a distinctive group in the community, that the representation of this group in the veneers from which juries are selected is not fair and reasonable in relation to the number of such persons in the community, and that this underrepresentation is due to systematic exclusion of the group in the jury selection process. While the defendant's motion avers that the statutory compensation of jury makes is practically impossible for wage laborers to serve on juries, there's no indication that these groups are actually underrepresented in the group from which the juries are selected, or that they are systematically excluded, even if the court were to recognize these as distinctive groups. Therefore, the state requests the court to deny the defendant's motion. Motion for compensation of jurors. So they want the jurors to get paid what they get paid for at their regular jobs. Wouldn't that be nice? That's what I got from that. I might be wrong. The next document is motion for additional preemptory challenges. Let's see. While the defendant has a constitutional right to an impartial jury, there is no constitutional right to preemptory challenges. Preemptory challenges are a statutory creation. Florida statute specifically states that defendants facing a sentence of death or life in prison will receive 10 preemptory challenges. Because there is no constitutional right to preemptory challenges, the state need not only have a rational basis for the statutes in question. Fair and efficient trials is such a rational basis. If during jury selection a need arises for the parties to request additional preemptory challenges, the court has the discretion to grant extra challenges. Therefore, the defendant's motion should be denied. We get minimum wage out. Wage in, out. Oh, really? Hey, Supreme View, good to see you. I thought you didn't get like when you went to jury duty. I don't know. Let me know if you've ever been and what you've gotten paid. The next document is state's motion in limine on trial procedures. Motions in limine. The state agrees that it is improper for the court to deem a witness an expert. Each party should lay the predicate for the expert's opinions and then ask the experts for these opinions. If the opposing party does not believe the predicate for the opinion has been laid, they can raise an objection. Because it is in the court's discretion to allow the indictment to go back to the jury with the standard caution that is merely an allegation and not evidence of guilt, it is therefore not improper for the court to mention the grand jury to the jury panel. The indictment has a signature line for the foreperson. The defendant's request for the state to only list witnesses it intends to call should not be granted. Requiring the state to disclose which witness it intends to call at trial violates the work product doctrine. Additionally, as things develop during trial, particularly homicide trials with dozens of witnesses, a witness the state originally did not intend to call may end up being called as a witness. And if one or more of the jurors knows the witness, this could result in jurors potentially being removed in the middle of the trial. This is an outcome nobody wants. Therefore, the court should grant the defendant's request regarding expert witnesses and deny the defendant's request regarding the term grand jury and reading all of potential witnesses. 875 in West Virginia. I believe it's $11 an hour. Really? That's not terrible. It could be better than nothing, I guess. The next document is motions in limine to prohibit prosecution from challenging certain potentials for cause. Good old Florida. On probation. Yeah. Argument. The defendant has requested this court to enter an order limiting the dismissal of trial jurors because of their attitude towards the death penalty. He claims that allowing the dismissal of trial jurors based on this basis deprives him from having a fair cross-section of the community serve on his jury and creates a jury that is conviction prone. The defendant appears to suggest that this court only allows dismissals for cause of jurors based on their attitudes towards the death penalty after the issue of guilt has been decided. The state maintains that a defendant's request is untenable. The defendant begins his motion by stating, quote unquote, that prospective jurors who have reservations about capital punishment, but which would not affect the verdict in any manner, may not be properly challenged for cause by the prosecuting attorney, in paragraph 1 of his motion. Then he states in paragraph 2, a prospective juror who has reservations about the death penalty, but whose attitudes would not prevent him from making an impartial decision as to the defendant's guilt or innocence, may not properly be excused for cause by the prosecuting attorney. Interestingly, the defendant then states in paragraph 5, quote unquote, while the prospective jurors with reservations about capital punishment as described above might properly be excluded for a jury impaneled to make a recommendation as to a penalty in a capital case, the state is at a loss for how to respond. Can prospective jurors with reservations about capital punishment as described by the defendant be excused for cause or not? What does reservations mean? Does that include potential jurors whose reservations are firmly fixed beliefs, or merely potential jurors who express opinions for or against the death penalty, but will follow the law? In a death penalty case, a juror is only unqualified based on his or her views on capital punishment if he or she expresses an unyielding conviction and rigidity towards the death penalty. The defendant appears to be using, quote unquote, reservations as meaning both classes of jurors. The state suggests that this confusion could be avoided by not citing cases, as the defendant does, that predate the abolition and reinstatement of capital punishment. It is clear this analysis using the term reservation. I'm going to skip that paragraph. The death penalty was deemed unconstitutional in 1972. No longer was a defendant in a capital crime subject to the whims of the conscience of the community standard without a far more elaborate capital sentencing scheme which required jurors to follow the law and not their hearts. Shortly after affirmation, the Florida legislature enacted Florida Statute 92.1, whatever. Since then, as this court is well aware, the Supreme Court in Lockhart versus McGree has held that separate juries are not required in capital trials. The Supreme Court also authorized, quote unquote, the death qualification of prospective jurors to the guilt phase of bifurcated capital trial. Furthermore, the Supreme Court held that the death qualification of prospective jurors does not violate the defendant's right to a trial by a jury representative of a fair cross-section of the community and does not result in a conviction-prone injury. Florida statute provides for exclusion of jurors in capital cases for those who were unable to set their personal views aside with regard to the death penalty. Despite defendants' assertion that this concept is unconstitutional, the statute has been repeatedly held to withstand any constitutional infirmities. Accordingly, this court must deny the defendant's motion where defendant is entitled to only one jury and the state may excuse for cause a prospective juror whose views on the death penalty would prevent or substantially impair the performance of his duties as a juror in accordance with his instructions and his oath. So the court denies the defendant's motion to prohibit prosecution from challenging certain potential jurors for cause. Like the DP is such a topic. I feel like it's hard to talk about because Like, we'd like to ideally say that a jury goes up there and doesn't take into account their personal beliefs and morals on the death penalty, et cetera, et cetera. But I think like we're humans, and so I think that's irrelevant. Like, I think people go up there regardless of what we see in the media. Like, who we are as people, I think clearly defines or factors into the decisions we make about and the judgments and opinions we have about the death penalty. Like, taking someone's life is, it's a difficult subject. And I think as much as we want to say like, oh, we're not being tainted by the media and whatever, et cetera, I think that's partly not true. I think that subconsciously what you believe and who you are as a person like comes out, in those in these moments. Hey Thomas. Okay, so the next document. So do you think Stephan Pig Vomit Sterns deserves the death penalty? If you know about the case. If you don't know about the case, you need to watch the playlist and look into it. It's horrific. The next document states respond to defendant's motion to be free from physical restraint and to use normal writing instruments. Not the criminal wanting like 5-star service in the courtroom. At least he can breathe and be in there, right? Unlike Maddie Soto. Yeah. Made me scared to have a jury of my peers judge me. Let me tell you that. That's what I'm saying. That's what I'm saying, Lynch. Not be biased. Natural bias kicks in regard. That's what I'm saying. Natural bias. Thank you. Yeah, I feel like who cares what the judge tells me? I'm gonna believe and go with what I believe are my morals and my beliefs, right? And what we think is wrong or right individually. Some of you might not think he deserves a death penalty. Others, like me, think he deserves it like tonight. Like it's already been too long. Hey, ATS, good to see you. This next document is, oh yeah, so he wants to be free from physical restraints. Unlike Taylor Schabusiness, if you saw her this last week, she was like all tied up. Anyways, the state agrees that evidence must be presented to the court for the court to make an individualized determination of the needs to restrain the defendant during trial. I agree, Melanie DP for Stearns. Yes, ATS. I'm disgusted with him. The state will call members of the Osceola County Sheriff's Office, which is responsible for courtroom security, for this evidence. The undersigned is unable to locate any Florida case law that extends this analysis to what type of pen the defendant is allowed to use at trial. I'm sick. No, he shouldn't be able to use a cool pen. No. He strangled Madeline Soto after abusing her for like 6 years. Was it 6 or 5? Regardless. I think Jen Soto needs to be, I already said this, she should get no pens either. The defendant at time raises the argument that he would not be subject to these restraint issues if he were not being held in custody pending trial. While this may be true, it is not because, as the defendant suggests, of his lack of financial means. It's the state's position that the proof of his guilt is evident, or that the presumption of his guilt is great, and that he is charged with the capital crime of first-degree murder. Thank you, Judge, whoever it is here, or Williams, Robert J. They're basically saying, is that what they're saying? That they don't care what pen he uses? The defendant at time raises the argument that he would not be subject to these restraint issues if he were not being held in custody pending trial. So what? He wants to go home and be on house arrest? I'm against DP per se. I'll make an exception for this case, said Dodge. Thank you, Dodge. Thank you. I appreciate that. Yeah. This case makes me really angry. Really angry. And sad, to be honest. The next document, we're just reading a couple more and then we'll continue tomorrow night because there's like 40 of them that came out. So And then we have Karen Reed. We're also following Karen Reed and Diddy. So I have another live planned. So make sure you subscribe, turn on the notifications, do all that stuff. So these were all filed on the 10th. So yesterday. States respond to defendant's objection to the use of follow the law questions to rehabilitate or qualify jurors. In a death penalty case, a juror is only unqualified based on his or her views. Wait, did we already read this? No. His or her views on capital punishment if he or she expresses any unyielding conviction or rigidity towards the death penalty. In 𝐿𝐭𝐫, a veneer man initially stated that the death penalty should be mandatory in some circumstances, but later indicated he could follow the law on weighing aggravators and mitigators. His answers revealed that he did not have an unyielding rigidity towards the death penalty, whereas here, a prospective jury initially states that one who murders should be executed, but later states that he can follow the law upon court instruction. The trial court does not abuse its discretion in denying a cause challenge. Therefore, both the defendant and the state should be permitted to inquire of prospective jurors if their opinions about the death penalty are rigid and unyielding, or if their opinion are not so inflexible that anyone has a reasonable doubt about their abilities to follow the law. This, of course, requires allowing both parties to ask if, after further questioning and explanation, the prospective juror can follow the law that the court will instruct him or her on following. That's a lot of following. Through questioning by the parties, a proper standard for the court to apply is whether a potential juror's views prevent or substantially impair the performance of his or her duties as a juror. If a reasonable doubt exists about the juror's impartial state of mind, the juror should be excused. Here again, the question of whether a potential juror could follow the law was permitted and appropriate. To the extent that the defendant's arguments and cited authorities stand for the idea that simply asking if a juror can follow the law is woefully inadequate, especially in capital cases, the state agrees with the defendant. Both parties need great leeway in exploring the potential veneer about their feelings regarding capital punishment. Therefore, the defendant's objection to either party or the court inquiring whether a potential juror can follow the law should be overruled. Geez, they're like bringing up everything. Hi, Jules, love. Good to see you. Oh my God, just get it over with. How much more evidence do they need? How many files was it? It was like 6,000 files of CSAM or something. 60, I don't know. The next document is state's response to defendant's motion to declare Florida Rule of Criminal Procedure unconstitutional. The defendant argues Florida Rule of Criminal Procedure violates his constitutional rights under the 5th, 6th, 8th, and 14th Amendments by compelling a mental examination by a state expert for the sole purpose of rebuttal against the defendant's mental mitigation. The defendant specifically complains Rule 3.202 creates a one-sided rule of discovery that violates his protection against self-incrimination, his due process rights, as well as his right to effective assistance of counsel. Finally, the defendant asked this court to find Rule 3.202 is unconstitutionally vague. The defendant's inability to distinguish clear precedent rejecting the argument leaves this court little choice but to deny the defendant's motion. The Florida Supreme Court addressed most of the defendant's claim in its decision in Kearse v. State. In Kearse, the defendant made nearly identical arguments that the compelled mental health examination constitutes unconstitutional one-sided discovery, and the introduction of the expert's testimony based upon the defendant's compelled statement violates the defendant's Fifth Amendment privilege against self-incrimination and limits the defendant's ability to present mitigating evidence during the penalty phase. Addressing the discovery argument, the Kearse court relied on precedent in concluding a compelled mental examination of the defendant by the state was necessary to level the playing field. The court stated by allowing the state's expert to examine the defendant, the state would have an opportunity to offer meaningful expert testimony to rebut the defense's evidence of mental mitigation. It would be unfair to permit a defendant to present mitigating mental health evidence at a penalty phase while denying the state the opportunity to present evidence on the same issue. He's a monster. Is he mentally sick? Yeah, I do think he's mentally sick, but I don't think that's why he did what he did. Allowing the state's expert to examine a defendant will keep the state from being unduly prejudiced because the defendant will not be able to rely on the expert testimony that the state has no effective means of rebutting. Thus, the Florida Supreme Court has heard and expressly rejected arguments identical to those raised by the defendant regarding the fairness of discovery and the defendant's due process rights regarding compliance. Rule 3.202, whatever. In Abdul's state, the defendant argued on appeal. The trial court erred in interpreting Rule 3.202 by ordering the defendant to turn over raw data from his mental health expert prior to the penalty phase. The Florida Supreme Court stated that Abdul's argument is that the Rule 3.2 somehow preempts the rule that the discovery rules no longer apply in the penalty phase. A review of the precedent also proves this truth regarding the defendant's argument on his right pursuant to the Fifth Amendment. Both the U.S. and Florida Supreme Courts have rejected the defendant's claim that there is a violation of the defendant's Fifth Amendment right against self-incrimination to require a defendant to be examined by a state mental health expert for purposes of penalty phase proceedings. If a defendant requests such an evaluation and presents psychiatric evidence, then at the very least, the prosecution may rebut this presentation with evidence from the reports of the examination that the defendant requested. The defendant would have no Fifth Amendment privilege against the introduction of the psychiatric testimony by the Constitution. Under those circumstances, we cannot say that the trial court abused its discretion in striving to level the playing field. The Florida Supreme Court in Davis reasoned it would be unfair to permit a defendant to present mitigating health evidence at the penalty phase while denying the state the opportunity to present evidence on the same issues. I thought in every death penalty case there was they did like mental health evaluations, I thought. Hey Dustin, it's good to see you. Hi Jules, I'm glad you're here. Exactly knowing what he did because he's a predator. PS. Exactly. Yeah, I thought everyone went through like a mental health screening prior to death penalty. No, if not, everyone should. That's messed up. No, I'm pretty sure people do. Defendant's final argument is that the section rule of 3.2 is unconstitutionally vague and that it gives no guidance as to which sanction to choose, and a sanction for excluding mental mitigation. The Supreme Court has also held, when reasonably possible and consistent with constitutional rights, this court should resolve all doubts of statute in favor of its validity. However, when there is doubt about a statute and vagueness challenge, the doubt should be resolved in the favor of the citizen. The defendant's argument is without merit based upon the clear, precise language of Section E. If defendant fails to cooperate with a state mental health expert, the trial court may remedy the situation as proscribed under the rule. The defendant takes issue with the fact that the rule allows a trial court to decide which of the two sanctions to impose, arguing too much deference is given to the trial court and the effect between the two possible sanctions is so great it would lead to arbitrariness. The statute is susceptible to arbitrary application when it has a catch-all nature. The defendant cites 𝐭𝐞𝐥𝐥𝐲 versus Ohio for the proposition that it is impermissible to impose a sanction excluding mental mitigation. The defendant's argument exceeds the scope of 𝐭𝐞𝐥𝐥𝐲. The analysis in 𝐭𝐿ockett focused on a new wave of capital sentencing after mandatory death sentences were deemed unconstitutional. The court in 𝐭𝐿ockett explored the realm of what a trial court should consider before imposing a sentence in a capital case. The court focused on death being qualitatively different from other sentences and stated such as penalty calls for a greater degree of reliability. 𝐭𝐿ockett is not a shield for defendant from the imposition of sanctions for failure to abide by the rules. Finally, the defendant asserts there is due process clause violation. The court specifically addressed this issue in Kearse when they finally conclude that the rule does not violate the defendant's due process right. Therefore, this court should also find there is no violation. Additionally, the defendant claims there's some sort of right to amend his claim during his hearing. This is legally inaccurate, and the defendant, as the movant, should have his arguments confined to four corners of his motion. Ironically, this is the sort of one-sided litigation by ambush Florida rule seeks to avoid. Wherefore, the state requests this court to deny the defendant's motion. I think it's just denied. D9099. Motion to declare for, I just read that, my bad. State's motion, Florida statutes on the stand. Okay, state's motion to defendant's motion to declare Florida statutes or the standard instruction unconstitutional facially and as applied. What does that mean? Let me switch it so if you guys can see what I'm on. Argument. The defendant complains that the Florida statutes and the corresponding standard jury instruction are unconstitutional as being vague and overbroad, and that this aggravating factor has been applied in arbitrary and inconsistent manner. Subsection relates to the quote-unquote prior violent felony aggravating factor. Initially, the state would point out that the constitutionality of Florida statute has been repeatedly upheld by the Supreme Court and the United States Supreme Court. Claims that the Florida's death penalty statute violates Florida federal and international law have also been rejected. The same holds true for claims that the Florida statute is unconstitutional facially and as applied. Furthermore, all recent constitutional challenges based upon Apprendi versus New Jersey and Arizona have been rejected. Regarding the statute, the state would point out that the constitutionality of this aggravating factor was approved, as was the direction given the judge and jury. Furthermore, the constitutionality of the aggravating factor has been upheld by the Supreme Court. The court has specifically held that the per violent felony aggravating factor, when based on contemporaneous crimes charged by indictment and on which a defendant is found guilty by unanimous jury, clearly satisfies the mandates of the United States and Florida Constitution. Wherefore, the state requests the court deny the defendant's motion. What does that mean? That the prior violent felony aggravating factor death penalty seems extreme. Yeah, what happened to Maddie was extreme too. I do agree with that. The next document is for corresponding jury instructions. Okay, so motion to declare Florida statutes or corresponding jury instructions unconstitutional, especially heinous, atrocious, or cruel factor. This crime is heinous and atrocious. For sure. Let's see. We're just going to read two more. The defendant asks this court to declare a Florida statute unconstitutional by directing the court to general precedents and language of the United States Supreme Court in Maynard versus Cartwright. Defendant argues the general principle of these decisions allow the courts to strike down a Florida law supporting that the argument with an appeal to what the defendant believes is a body of inconsistent case law interpreting Florida statute. The defendant argument stands contrary to established Florida law declaring and then affirming the constitutionality of the Florida statute and expressly rejecting the argument that the defendant makes to this court. Moreover, the defendant's argument that the Supreme Florida Court has inconsistently applied the quote-unquote heinous, atrocious, and cruel aggravator is based upon case law that predates a legislative overhaul of that term's definition. The standard heinous, atrocious, or cruel jury instruction is not unconstitutionally vague. Significantly, the Florida Supreme Court's definite announcement in Randolph came 10 years after the Supreme Court first rejected the defendant's vagueness argument 25 years ago. The instruction used by trial court and law affirmed by the Florida Supreme Court is identical to the instruction the defendant asked this court to find unconstitutional, and that goes much further in defining the terms heinous, atrocious, and cruel than the instruction deemed unconstitutional in Espinoza. Heinous means extremely wicked or shockingly evil. Atrocious means outrageously wicked and vile. Cruel means that designed to inflict a high degree of pain with utter indifference to or even enjoyment of the suffering of others. The kind of crime intended to be included as heinous, atrocious, or cruel is one accompanied by additional acts that show that the crime was conscienceless or pitiless and was unnecessarily torturous to the victim. Yes. What? Like, why is this even in question, dude? He was raping her since she was 6 years old, giving her drugs, raping her while she was passed out on drugs for like 7 years, and then freaking strangled her and throws her on the side of the road in the woods. I mean, and once you read the details, make sure you check out the playlist. We read a lot of the documents. I'm disgusted. I think this qualifies as heinous, atrocious, or cruel, and I think they need to suck it up. This sounds like Brian Koberger, where he's like, hey, you shouldn't be able to use this against me, that I'm a monster. And it's like, well, what did you think you were? Like, the defendant fails to cite or in any way discuss or distinguish the holdings in Espinoza-Randolph that are directly contradictory to his position. Moreover, though, the defendant cites the court to multiple opinions he argues demonstrate Florida statute in consistent application. Only 2 of those opinions address the statute languages after it was amended and affirmed in Hall. The defendant's inconsistent application analysis is also flawed in what it focuses solely on the method a criminal defendant used in committing the unaliving, whether it be stabbing, beating, gunshots, or strangulations. Of course, the focus of the HAC aggravator centers on the means and manner in which the death is inflicted upon the victim and the victim's perception of the surrounding circumstances. Furthermore, we have held that in determining whether the HAC factor was present, the focus should be upon the victim's perception of the circumstance as opposed to those of the perpetrator. The defendant conducts his analysis by isolating one aspect of the murders while ignoring the victim's perceptions and surrounding circumstances present in each case. Analyzing heinous, atrocious, and cruel cases by looking solely at whether the victim was shot, stabbed, or strangled ignores the distinctions in the case that factor into making the finding. Therefore, considering the defendant's erroneous analysis and the Florida Supreme Court's precedent declaring the heinous, atrocious, and cruel aggravator and corresponding jury instruction constitutional, this court should deny the defendant's motion. Aggravating is a prior crime which increases the likelihood of guilt for the present crime. Sterns is a monster. Oh, he's a demon. Don't commit heinous crimes in a DP state. Pretty simple. Right, Dodge. Yeah, I don't think anything can change my mind about how I feel about this case in Stephan Sterns. I'm not usually for the death penalty either. It's not something I rush to, right off the bat. But I think definitely in this case, yeah, I think, you know what? I don't know. And in the Brian Koberger case too, I mean, that's 4 lives. That's 4 lives. That's considered a serial killer, right? Okay, so the next document is defendant's proposed implicit bias jury instruction. The defendant proposed implicit bias jury instruction request does not include any allegations or arguments which, if shown to be true at an evidentiary hearing, prove the need for the court to include such an instruction in the jury instructions in this case. In fact, by all appearances, the defendant appears to be a white male and the victim appears to be a white female, though the surrounding evidence will inform the jury that the victim was also of Hispanic heritage. Therefore, without the defendant specifying what type of implicit biases he is concerned with the jury having, and race apparently not being that issue, the state is also at a loss to understand what implicit biases he's concerned the jury may have. Legal academia has been exploring this issue of implicit juror bias since at least 2012. I'm going to skip that part. The undersigned was able to find only one such instruction given in a criminal case in Florida, State versus Young. In at least 13 years that legal academia has been writing about this issue, the Florida Supreme Court has not adopted a standard jury instruction about implicit bias. The state would strongly caution that the court against taking on the task for itself, rather than allowing such a proposal to go through the process of being proposed and approved by the Florida Supreme Court. Furthermore, because no particular implicit bias issue has been raised by the defendant in his proposed instruction, there's no legally sufficient motion for the state to respond or the court to grant the relief requested by the defendant. What is the defendant going to prove at this hearing that necessitates such an instruction? Therefore, the defendant's request should be denied. That's funny. I think there's only been one partially approved motion, right? Okay, we're going to stop there because I don't want to make it too long with my reading, even though we read thousands of documents on this channel. I can't wait for this trial. I really can't. Wait, are death penalty cases, are we able to watch those? I think we are, right, media? I'm going to look into it. I have lots of questions about death penalty cases. If you're not caught up on Stephan Sterns' Madeline Soto case, please go back and watch my playlist. I have phone calls. We have the videos. We have court documents. We'll continue on part 2 tomorrow. Continue reading the 40 documents that there are out. I'll probably go through them ahead of time and select the ones that I really want to read. Today, I just kind of pulled through the docket, got all of them. So we'll continue this Maddie Soto case just because it's not, in the media right now. I know it's like the Diddy case and Karen Reed and the Sade Robinson one that I'm going to be covering too. I know. I'll check the case. I'll check if the case will be right. Yeah, there's a lot going on, but remember, this is one of the biggest cases too. I think along with Brian Kohberger is the Maddie Soto case. And I hope that Maddie gets justice. And I hope that Jen Soto has to do time too. And I hope I see you guys on the next live right after this. We are covering Karen Reed. So head on over there. I will see you in about 10 minutes. Thank you for being here. Make sure you hit the like button on the way out if you are done for the night. If not, I'll see you over there. We just hang out, go drink, chit chat over there. Have a good time. I appreciate you guys for being here, and I will see you on the next one.